The next matter is cause number 49553, Marc Manuel Ariza.
Judith DeBerry on behalf of the Commission for Lawyer Discipline.
Please proceed.
This is a compulsory discipline based on respondent's conviction for false statement to obtain credit, a first-degree felony in the 263rd District Court, Harris County, Texas. We filed our first petition for compulsory discipline on November the 15th, 2011. The second amended petition was filed on April the 10th, 2012. The third amended petition for compulsory discipline was filed on August the 28th, 2012. And the fourth amended petition for compulsory discipline was filed on December 7th, 2012. Respondent was personally served with the fourth amended petition and notice of this hearing on December the 13th, 2012 by John Patterson, a private process server. Proof of service has been on file since December the 19th, 2012. On April the 2nd, 2008, Marc Ariza was charged by indictment with engaging in organized criminal activity. In case number 11-60642, styled the State of Texas versus Marc Manuel Ariza in the 263rd District Court, Harris County, Texas. On July 17th, 2009, an order of deferred adjudication was entered wherein respondent pled guilty to false statement to obtain credit, a first-degree felony, and was placed on community service for a period of 10 years. He was ordered to serve 90 days in the Harris County Jail and to complete 500 hours of community service. He was to pay restitution of $51,870 to Farmers Insurance Company and to pay a fine in the amount of $10,000. He was also ordered to pay court costs of $203 and not to engage in the practice of law in any real estate matter. This time I'd like to offer Petitioner's Exhibit number 1, which is a certified copy of the indictment, Exhibit number 2, which is a certified copy of the order of deferred adjudication, Exhibit number 3, which is my affidavit attesting to the fact that Marc Manuel Ariza, the respondent, is the same person as the person identified as the defendant in the case, and the original order from Blake Hawthorne, Clerk of the Supreme Court, dated April the 3rd, 2015, indicating that respondent is licensed but not currently authorized to practice in the state of Texas. May I approach?
Yes. Exhibits 1, 2, 3, and 4 are admitted.
Thank you. At this time, I call Nancy Ashcraft. Please state your name for the record.
My name is Nancy Ashcraft.
And how are you employed?
I'm the statewide compliance monitor for the Office of Chief Disciplinary Counsel.
And how long have you been in that position?
7 years and 2 months.
And as the compliance monitor, are you familiar with cause number H00595095542, H01295112661, H00696129946, H00696129977, H00896133304, H00896133355, H00197146110, H005971564, and H01096144057.
Yes.
Okay. And what was the sanction that was imposed in those cases?
That was a 6-year partially probated suspension with 3 years active, contingent upon completion of specific terms of the judgment.
And those were all cases styled the Commission for Lawyer Discipline versus Marc Manuel Ariza?
Yes.
And what were the terms of that judgment?
he was required to pay attorney's fees of $2,000 to the State Bar of Texas, restitution of $2,530 to Kathy Sullivan, restitution of $5,915 to John Nash, provide proof of compliance with his agreement to pay restitution of $22,850 to Planet Insurance Company. He was to submit to psychological evaluation and submit quarterly reports to the State Bar for the full term of the active suspension, and he was to comply with all MCLE requirements and maintain a current status with the membership department by current fees and dues. He was to notify clients of his suspension and return files, papers, unearned monies, and other property belonging to clients, and to submit an affidavit to the State Bar of Texas stating that he had done so. He was to notify courts, all the courts of the terms of the judgment, and submit an affidavit to the State Bar of Texas stating that he had done so. And he was to surrender his law license and State Bar card to the State Bar of Texas.
And was his return to active practice or active status contingent on him complying with the terms of the agreement during the first 3 years?
Correct.
Did Mr. Ariza comply with the terms of the judgment?
No, he did not.
Specifically, did he pay any attorney's fees to the State Bar of Texas?
No.
Did he pay restitution to Kathy Sullivan?
No, he did not.
Did he pay $5,915 to John Nash? Was there any proof of compliance with his agreement to pay restitution of $22,850 to the insurance company? Did he submit to a psychological evaluation?
To my knowledge, no.
Did he give us any quarterly reports concerning treatment? Did he, well, I'll get into that in a minute. Okay. Did he submit affidavits that he had notified the courts and his clients? Did he turn over his bar card or law license?
No, ma'am.
Did he submit an affidavit that he had lost those items? Okay. That's all the questions I have. One more. When was he returned to active status?
He was returned to active status effective June 1st, 2006.
Okay.
Excuse me, do I understand correctly that he didn't do any of those things and he was still returned to active status?
Yes. I'm sorry.
Is it a default thing?
He was not returned at the end of the 3 years active. At the end of the 6-year partially probated suspension, we have no choice but to return them to active status.
Okay, thank you.
Any other questions of the witness?
Why didn't you have any choice?
Because it's for a term certain. We have a choice when it's contingent, when his return to active status on a partially probated is contingent upon him completing certain requirements during the first 3 years. We don't have to return him until he complies. But at the end, because that's the end of the sanction, we have to return him to active status.
But there were other terms of the sanction that weren't complied with.
He didn't comply with any of the terms of the
I
sanction.
know, so if he just complies with one, that does it, the temporal one? Otherwise, he can ignore the others? I'm just trying to understand what your policy is.
Yeah, that's why she's here.
No, he can't ignore them.
Well, he did, and you reinstated him anyway.
Well,
That's why we're here.
well, that's part of it. Yeah, that's why we're putting this on. Right after that,
Well, were the terms of, were the restitution, was that the term of the probation? So that if he didn't comply, I guess you could revoke his probation, but he never got reinstated.
we cannot do an indefinite disciplinary suspension, which is what you would have to have in place in order to continue that suspension until he complies with everything. Our rules don't allow for an indefinite disciplinary suspension. It has to be for a term certain. So we have no choice at that point but to return them.
If somebody doesn't pay the attorney's fees that are assessed against them, is your option to just file suit and seek collection of a judgment?
We can do that. We can also, and I think there was, and I wasn't here at the time, so I don't know why, but our other option is to then also initiate another disciplinary sanction, proceeding against them from not complying.
Okay. regardless, we're here on your request to disbar.
Yes, absolutely.
Okay. Any other questions for the witness? Be excused.
Okay, at this point, I would like to ask the panel chair to take judicial notice of the prior discipline of respondent, which is on file with the board and in the file, and I'll just go through that. In 1994, there was an agreed private reprimand wherein respondent violated Rule 1.15B.
Let me tell you what I think I'd like to do, and I'm happy to take judicial
That's
notice.
fine.
I will admit all the documents that are attached to your pleading as evidence in this case.
Okay, that's fine. Just wanted to bring some of those out because
Yeah, and if you'd like to review those for us, just to bring our particular, they're in evidence now, but if you want to focus our attention on them, please feel free to do
Okay,
so.
let me do that real quickly then. He also had an agreed private reprimand in 1995 for violating rules 1.14B and C and 8.01B. In 1998, he had a public reprimand for violating rule 8.04A8 and 8.04A11. The partially probated suspension, which we just discussed, was in 1999, and in that case, there were 2 counts of violating Rule 1.01B1, 2 counts of violating 1.01B2, 2 counts of violating 1.03A, 5 counts of violating 1.14A, 4 counts of violating 1.14B, 1.15D, 5.03A, 5.03B1, 5.05B, 8.01B, 8 counts of violating 8.04A1, 3 counts of violating 8.04A2, 4 counts of violating 8.04A3, 4 counts of violating 8.04A8, he violated 8.04A11, and 2 counts of violating 8.04A12. At this time, I would like to read some deposition testimony into the record. And also, it's been the Blake Hawthorne affidavit has been admitted, and I would ask you to take notice of the fact that he was administratively suspended in September of 2011, has not been reinstated at that time. Okay, this deposition was taken on March the 15th, 2013. Daniel, for the record, would you please state your full name?
Daniel Richard Young.
What was across the street from your apartment?
Across the street is a nightclub now called Club 305.
Okay, and briefly, what problems have you had with that nightclub?
The major problems with the nightclub are noise. They've also had a lot of problems with fighting that basically comes out into the street and whatnot, but mostly it's the noise.
And so what have you done to try to resolve those issues?
Since I moved there, I just worked quite a bit with the city and the other authorities. When I first moved there are actually two nightclubs on those corners.
Okay.
And they both play just out of control, like I assume it is in other parts of the city. At the time, the noise levels, they just played as loud as they wanted to, as it was just out of control as it is in the other parts of the city at the time. I just worked very steadily with HPD and the city to make sure that the noise ordinance and the other rules were enforced.
And now how are you familiar with Marc Ariza?
Marc Ariza came to the building and identified our building. It has restricted access, so he identified himself to the assistant property manager, Randy, and he came up and told me that the lawyer for Club 305 was downstairs.
And so he came to your building?
Yes. One of the partners in the club, a Bentley Williams, approached me in the street in that conversation, and he seized on something I said, which was my only other alternative for this situation to meet the rules. Kind of seized on that.
Uh-huh.
and came up, and I just told him it was illegal, this was a legal matter, and I'd rather it went through the lawyer. And I think it was a day or two later, Mr. Ariza came to the building.
And so was that your first encounter with Mr. Ariza?
Yes.
And I believe you've already said he represented Club 305?
Yes.
And when you met with Mr. Ariza, did he tell you he was an attorney?
He must have told Randy. We could play those recordings, but I couldn't say definitely that he stated verbally that he was an attorney.
But it was your understanding that he was an attorney?
Oh, yes, yes. It was my understanding that he was drawing up, in the conversation, he would draw up the documents. He would serve as the escrow officer, which were things that I asked him for.
So was it,
It was my clear understanding that he was an attorney.
when you spoke, you said you had talked to Mr. Ariza about drawing up an agreement. Who did you first discuss the agreement with?
With Bentley Williams, but we really didn't get into an agreement. He just kept pushing that point. We'll cover you on that. We'll take care of your expenses to move. I didn't think they really understood how much we were really going to be talking about.
Okay.
So I just told him,
Uh-huh.
it needs to come through your attorney.
Okay.
So the agreement and the details of the agreement, I only spoke with Mr. Ariza.
Through the attorney, okay. So was it your understanding then that Mr. Ariza was the attorney for Client 305?
Yes, absolutely.
And did you ever speak to Mr. Ariza by phone?
Yes.
On how many occasions, do you recall?
Just the one occasion he called me regarding the details of the contract.
Was that after you had met with him in person?
Yes.
Okay, did you also have email communication with Mr. Ariza?
Yes, I had the two emails that contained the contracts and the original contract and the revised contract.
At this time, I'm going to show you what's been marked as Exhibit 1. Can you identify that for me?
Yes, this is the first email I received from Mr. Ariza.
Is that a true and correct copy of the email you received from him?
Yes.
At this time, I'd like to admit petitioner's Exhibit number 5. May I approach?
Yes. Is this the February 12th, 2013 email?
That's the first email that was sent, yes.
Exhibit 5 is submitted.
And I'll give you a copy to read. All right, please read the date of the first email.
Tuesday, February 12th, 2013.
And who is the email from?
Mr. Marc Ariza.
And what is Mr. Ariza's email address?
marcariza@gmail.com.
Okay, and who is the email sent to?
It's sent to club305houston@gmail.com and danielyoung007@hotmail.com.
Would you read the body of the email aloud, please?
Hello, gentlemen. Please find attached a settlement agreement for your consideration. Money will be tendered this evening if both parties agree to the terms and conditions. Thank you in advance, Mark. If you have any questions or concerns, give me a call at 832-435-2116.
Was there an attachment to this email?
Yes.
And what was attached to the email?
It was a copy of the original settlement agreement as referenced in the email.
Okay, now then, let's go to the second part, which was contained also on this email. Would you read the first paragraph aloud for me? Just read the first paragraph for me.
Yes. The information in this email is confidential and may be attorney-client privileged. It is intended solely for the addressee. Access to this email by anyone else is unauthorized. If you are not the intended recipient, any disclosure, copying, distribution, or any action taken or admitted to be taken in reliance on it is prohibited and may be unlawful. Please notify the sender and destroy the email. This email is personal and may not reflect the opinion of the Ariza law firm.
All right, did the first paragraph of this email reinforce your belief that Mr. Ariza was an attorney?
Yes, yes.
What portion of that paragraph, please, was that?
Well, the first line where it refers to attorney-client privileged, and then the last line where it says the Ariza law firm, which is, of course, his law firm.
Thank you. Just briefly, look over the rest of this. Is there anything else in the rest of the bottom portion of this email that would further verify your belief that Mr. Ariza was an attorney?
Well, the only other thing, I suppose, would be that he refers to it as being legally privileged. I mean, I just don't know why anyone else would use that type of language.
Okay, thank you. So you had testified a few minutes ago that a settlement agreement was attached to this.
Yes.
And you read that settlement agreement?
Yes, I did.
And did you have a response to anything about the agreement that you responded to Mr. Ariza about?
Yes, there were a couple of terms in the agreement that I wanted to be altered.
Okay, and what did you do?
I emailed Mr. Ariza with those exact requests.
Okay, I'm going to show you what's been marked as exhibit number 2 and ask if you can identify that for me.
Yes, this is the second email I received from Mr. Ariza where he acknowledges he received my email reply.
Okay, and is that a true and correct copy of the email to Mr. Ariza's, reply to Mr. Ariza's second email to you?
Yes.
Okay, we'd like to offer this as exhibit number 2. I'm sorry, this is exhibit number 3. I need to back up. It's actually exhibit number 3. And at this time, I would offer petitioner's exhibit number 6. May I approach?
Yes. Exhibit 6 is submitted.
Okay, when did you send your response to Mr. Ariza?
It would have been the next day. Yeah, Wednesday, February 13th.
No, your response, not Mr. Ariza's response.
Oh, I'm sorry. My response came, I believe, the following morning when I actually read his original email.
And did Mr. Ariza respond to your email?
Yes, he did.
And when did he respond to your email?
He responded later that day, Wednesday, February 13th.
What's the email address that this was sent from?
It was sent from marcariza@gmail.com.
And who was it sent to?
Daniel Young at danielyoung007@hotmail.com.
And was there an attachment to this email?
Yes.
Would you read that email aloud, the body of the email aloud for me?
Hello, Daniel. I acknowledge the issues you have with the document, and I have taken it upon myself to make the changes. Therefore, I have made the changes to reflect your apartment number and the 1 mile distance from Club 305. Please find attached the corrected version for your signature. Thank you in advance.
And was there a new settlement attached to this?
Yes, there was.
I'm going to show you what's been marked as petitioner's exhibit number 2. Can you identify this for me, please?
This is the original settlement agreement prepared by Mr. Ariza.
And is it a true copy and correct copy of the one that was attached to the email from Mr. Ariza?
Yes.
Okay, at this time I'd like to offer a petitioner's exhibit number 7. May I approach?
Yes, 7 is submitted.
Was this the agreement that was sent with the second email?
Yes, this is the revised agreement.
Did you sign this agreement?
No.
Can you tell me why you decided not to execute the agreement?
Mr. Ariza had been evasive in his conversations with me, and he was evasive about the correct spelling of his name. In our first conversation, I asked him for a business card, and he said he didn't have one. And in our phone conversation, I pressed him again on his last name. I first asked if he spelled it Aretha, as it sounded like Aretha Franklin, and he said that would do. I pressed him a little further for the actual spelling, and it was only then that he gave me the actual spelling of his name. I was a little suspicious of both the club owners and Mr. Ariza, so I looked at Mr. Ariza to make sure he was really an attorney. And that's when I discovered that he was really an attorney, but he was not licensed. His license had been suspended. So I considered the agreement invalid.
Okay, and what did you do when you discovered that he was suspended?
I emailed the club owner and made him aware of it and told him that I considered the agreement dead because Mr. Ariza was not a licensed attorney, and then I notified the Bar Association of what happened.
Mr. Ariza has a history of violating both the disciplinary rules, the laws of the state of Texas, and failing to comply with the legal obligations that he's required to in order to practice law in the state of Texas. He's intentionally violated a disciplinary judgment. when he didn't comply with the terms, and it shows a conscious disregard for the disciplinary system. A review of his record as a lawyer reveals the following. He was licensed in 1989. In 1994, he received a private reprimand. From September to November of 1994, he was administratively suspended for failing to pay bar dues. From September 1995 to April of 96, he was again suspended for failing to pay bar dues. In November of 1995, he received another private reprimand. From April to June of 1996, he was administratively suspended for failing to pay the occupation tax. From September to November of 1997, he was suspended for failing to pay the bar dues and occupation tax again. In July of 1998, he received a public reprimand. In September of 1998, he was again suspended for failing to pay his bar dues. In 1999, he received a 6-year partially probated suspension, which he served 6 years because he did not comply with the terms of the judgment. In June 1st of 2005, he was returned to active status, and beginning in 2005, he engaged in the very acts that resulted in his criminal conviction. July of 2006 to February of 2007, he was again suspended for failing to meet minimum continuing legal education requirements. From August to November of 2008, from September 2009 to March 2010, he was again suspended for failing to pay bar dues and his occupation tax. July 2009 was his conviction, and from September 2011 to the present, he was again administratively suspended for failing to pay bar dues and his occupation tax, and yet he continued to practice anyway. In fact, he continued to practice after he got a continuance from the last hearing that was scheduled in January, when he practiced and presented the settlement agreement to Mr. Young in February. In this case, Mr. Ariza's crime was directly related to his law practice. He has a substantial disciplinary history and has not complied with prior judgments. He was granted a continuance, and even though he was suspended, continued to practice after that. Mr. Ariza does not deserve to keep his bar license, and I respectfully ask that you enter into a judgment disbarring him.
Any questions of Mr. Berry? Just so that the record's clear, I had earlier admitted the attachments to your pleading as an exhibit. Some of them have been admitted as other exhibits. Let's go ahead and identify those attachments collectively as Exhibit 8, so that we'll have a clear record. So,
Okay, which exhibits are those?
all the ones that you attach to your pleading are all together admitted. Some of them you have admitted separately, but there are some of those documents that are attached to your pleading which have not been identified as a particular. So that whole attachment is one exhibit, Exhibit 8, which is admitted.
Okay, thank you.
Okay.
I have one question.
Yes.
Real quick before you leave. To your knowledge, is Mr. Ariza still on deferred adjudication, or has he been adjudicated?
To our knowledge, I had our investigator contact his probation officer, and in January, we were told that he was in compliance. This time, she would not give him any information.
Okay. Because he could be adjudicated and still be placed on regular probation as opposed to deferred adjudication. You understand that?
Yes.
But you don't have any knowledge that there's been any action on his probation to adjudicate him
No.
guilty at this time?
The probation period is 10 years, so
Right.
at that point, I guess they'll take an action.
Okay.
Any other questions?
Anything else?
Thank you.
Before we close this hearing, let me make one last announcement for Mr. Ariza. If there's anybody representing him, or if he is present in the courtroom, seeing no answer, we'll conclude the hearing on this matter, and we'll advise you of our conclusion in writing.
Thank you.
Thank you.